Welcome back to another explainer. Today we're unpacking what is basically a giant high-stakes game of tug-of-war in modern legal history. It's the ultimate balancing act. We're looking at that constant, ever-evolving tension between your individual liberty and the welfare of the broader public. Because think about it. How does a nation that's literally built on the promise of freedom figure out exactly where your rights end and society's rights begin? So let me just pose a direct question to you right out of the gate. Are your constitutional rights absolute, like 100% unbreakable? Now, the Indian Constitution, specifically under Article 19, grants us some of the most incredible, expansive freedoms you could possibly imagine. But the short, resounding answer to that question, no way. They are absolutely not absolute. And honestly, the reasons why are just fascinating. All right, here is our roadmap for today. We're going to walk through 5 quick chapters. First, speech and its limits. Second, gathering, moving, and settling. Third, the freedom of enterprise. Fourth, we'll hit the climax with the great property conflict. And finally, a right demoted. Let's get right into it. Okay, let's dive into this by defining what is basically the linchpin of our entire analysis today. The magic phrase here is reasonable restrictions. So for every single freedom you're granted, the state can actually impose limitations. But, and this is a big but, they have to be lawful, they cannot be arbitrary, and they must be proportionate. It's kind of like a legal shock absorber, right? It's a mechanism designed entirely to balance your individual freedoms with the general public welfare. Moving on to Section 1, Speech and its Limits, the core of democracy. Now, Article 19(1)(1)(a) guarantees freedom of speech and expression. And remember, this is a right born from a really long, bitter history of fighting harsh colonial censorship. The framers totally understood that without free discussion, political accountability is pretty much impossible. But notice the dialectical tension here. On one hand, you have this incredibly expansive, beautiful right, speaking, writing, printing, digital expression, the whole shebang. But on the flip side, the state holds the power to restrict it under Article 19(2). Why? Well, because a nation has to protect its sovereignty, its security, and public order. You can't just use your free speech to, say, incite a riot or defame someone. It is this constant, delicate weighing of the scales. And the courts? They are actively weighing these exact scales. Take the landmark Shreya Singhal case, for example. The Supreme Court actually struck down Section 66A of the Information Technology Act. Why? Because they deemed it an unreasonable restriction on free speech. It's a brilliant little mini-narrative, really. When the state goes too far and those restrictions become arbitrary or just way too excessive, the judiciary steps right in to protect the core of our democracy. Chapter 2, Gathering, Moving, and Settling. Basically, our physical liberties. So we're shifting gears from what you can say to where you can go. Looking at the physical freedoms covered under Articles 19(1)(1)(b), d, and e, you've got the right to peacefully assemble, to travel without internal borders, and to settle down anywhere, which really helps create this unified national identity. But look at the counterweight. The government can apply the brakes for public order, and crucially, for the protection of scheduled tribes. The state actually has a strict constitutional mandate to preserve tribal cultures and land rights, keeping them from being overwhelmed by completely unrestricted outside settlements. To make this a bit more tangible, when can the government actually legally restrict your physical mobility? Well, during a public health crisis, quarantine regulations are entirely valid restrictions. Curfews during security emergencies? Also valid. And as the Supreme Court discussed in cases like CrPC, which heavily debated personal liberty, restrictions for public safety are totally sound legally, just as long as they aren't excessive. All right, on to Chapter 3, the freedom of enterprise, economic liberty. Right after independence, India really needed to reverse those restrictive colonial economic policies. So they granted the right to form associations, unions, and to practice any trade or business. The overarching goal was equal economic opportunity and welfare-oriented development for everyone. But again, your economic freedom is carefully balanced against public safety. You have the freedom to choose your profession, sure, but there are strict guardrails. You can't just suddenly declare yourself a surgeon tomorrow, right? The state can, and does, impose professional and technical qualifications. Plus, the state can create monopolies if it's in the public interest. Think about the government running exclusive public transport networks or taking over the liquor trade. Actually, here's a really crisp, kind of surprising fact for you. You cannot claim a fundamental constitutional right to run an illegal gambling operation. No way. Activities that are inherently harmful to society, like gambling,
illegal trade, or obscene businesses, they simply do not get that protective shield of fundamental rights. So yeah, economic liberty definitely has its hard limits.
Which brings us to Section 4, the Great Property Conflict. This is a true constitutional climax.
We have officially reached the absolute climax of our explainer today. If you want to see where individual rights collided head-on with state welfare, this is it. The historical evolution of the right to property is literally one of the most tumultuous, high-stakes battles in all of constitutional history. Let's walk through this chronologically. Back in 1950, Article 19(1)(f) made property a fundamental right, but almost immediately in the 1950s, the newly independent government wanted to execute these sweeping land reforms, abolish the zamindari system, and redistribute wealth. Well, as you can guess, this created massive legal conflicts. It eventually led to the 1973 Basic Structure Doctrine and finally culminated in 1978 with the 44th Amendment, which just fundamentally altered the Constitution.
Now, right at the center of this massive battle was the doctrine of eminent domain. Basically, it's the state's power to compulsorily acquire your private property for a public purpose, provided they pay you compensation. But here's the catch. What exactly is just compensation? That one question forced the Supreme Court into some incredibly aggressive, landmarked debates. Take the Bella Banerjee case, for instance, where the judiciary heavily scrutinized what the government's idea of a fair payment actually was. To protect their sweeping land redistributions from just being struck down by the courts, the legislature decided to fight back by forging some incredibly powerful new legal shields. Parliament created Article 31A for agrarian reforms. Then, they created Article 31B and the absolutely famous Ninth Schedule, literally designed to give laws immunity from fundamental rights challenges. I mean, it was an epic, decades-long showdown between lawmakers trying to enforce social justice and the judiciary trying to protect individual rights.
And that brings us to our final chapter, Section 5, A Right Demoted, from Fundamental to Legal.
So this is where all that intense constitutional tension over property finally snaps and resolves into the system we actually have today. Pre-1978, you had a fundamental right to property under Articles 19 and 31, but today, it's merely a legal right under Article 300A. So the crucial takeaway is this. The 44th Amendment definitively ended the war by prioritizing the collective socioeconomic good over absolute individual ownership. They literally just deleted the fundamental right to property from the Constitution.
But hey, don't panic. That doesn't mean the state can just show up and take your house tomorrow on a whim. The new reality is cemented in Article 300A, which clearly says no person shall be deprived of his property save by authority of law. So your property is absolutely still legally protected from arbitrary, lawless seizure. But by stripping it of its fundamental status, the government essentially made it much, much easier to execute infrastructure and welfare projects without running into endless constitutional roadblocks. And yet, a safety net still remains. While property rights shifted, the Supreme Court made absolutely sure that democracy's foundations stayed firm. Through the monumental Keshavananda Bharti case, which was later affirmed in the I.R. Coelho case, the courts established the basic structure doctrine. Basically, this means even those highly protected Ninth Schedule laws that Parliament created can still be judicially reviewed if they violate the very core principles of the Constitution. So the ultimate balance of power remains perfectly intact. So, we end right where we began, with the ultimate balancing act. Where do you draw the line between your personal liberty and the welfare of society? It's wild to think about, but every single day, through new laws, tech regulations, and Supreme Court judgments, that line is constantly being tested and redrawn. Thank you so much for diving into this explainer with me today. Keep reflecting on how these constitutional balances apply to your own daily life, and as always, keep learning.